Since is there, may I pray for listing on 27th of September?
27.
My lord. Because 25th is
Have it on 27, all right.
I think to mention for listing lordship of matter in orders lordship. The matters relates to lordship pensionary benefit. And notice was issued in lordship June. Thereafter matter has not been listed lordship.
29th?
29th.
Yes.
Lordship. This matter may be listed on next week, on Thursday, my lord, 28. Matter promotional matter. The petitioner has already retired from service.
For admission?
For order, my lord.
For orders. Then you have it on 27th or 29th?
27th.
27th.
Okay.
All right, 27th.
But back to mention item number 25, 26 on supply list. Also, the respondent 6 has filed their affidavit yesterday. We have received the copy. We need some time, Lordship. Any date next week, Lordship.
25, 26 at the request made by the counsel for petitioner stands adjourned to be listed on 29.
May please, I'm praying for listing for order of 29 minutes, pension matter.
29.
Maybe it's listed, Lordship. I beg to mention for listing of, in this case, Lordship, for pensionary benefit, Lordship. One is pensionary benefit, other is for compensatory benefit, Lordship. Let it be listed on 1st of September, Lordship.
You are not properly robed.
Sorry, Lordship. Sorry, Lordship.
All right, give it 29th.
20.
Yes.
Please, Lordship, with the consent of the other side, I beg to mention item number 22, Your Lordship.
I'm for the petitioner, Your Lord.
22.
22, Your Lordship. We have prepared the
Yet
affidavit.
somebody has listed it by orders. Who has listed it?
We have.
Then why are you agreeing for an adjournment?
So we are going to file our affidavit in reply, opposition, Your Lordship. We have sent it for signing, it has not come as yet. Can it be on 8th of September, Your Lordship?
Yes. 8th of September,
Obliged.
Deeply obliged.
item 22, on the request by the counsel for respondent.
I beg to mention for listing the petition lawsuit. Matter was last listed on 21/4/2020.
What is the matter?
Matter was lawsuit pension lawsuit.
Pension, 29th August, 29th August.
It was a beg to mention item 23. Lord, an affidavit was to be filed, my lord. It has affidavit is ready, my lord. It had to come from Mizoram. My lord, 1 week time, Lord, I have taken consent. They are also
Item
having
23 be listed after 2 weeks.
No, very small matter. Already one arbitration application around of the same
date maybe.
last week was the valid matter.
8th of September?
No, no.
8th?
No matter, a bit difficult matter. 2nd of September or 3rd of September.
Well, his bench is not available.
My lord, then 27, 28 of August.
All right, 27, 28.
No, no.
Matter. Grateful, man.
May I please, Lordship? Lordship, I beg to mention WPC number 2558/25 for listing. WPC number 2558/25 for listing.
What is that matter about?
Service
Subject matter?
Service matter, Lordship.
Service of what?
Suspension, termination, key approval.
Relating to what?
Pension.
All right, have it on 1st of September. 1st September.
Okay,
May I please, Your Lordship? My lord, I beg to mention motion item 11, my lord. My lord, what has happened after filing of this petition, my lord, some developments are there as I have been instructed, my lord, to withdraw with the liberty to pray before my lord. My lord.
Item 11 on the request submissions made by Mr. A.R. Via, matter stands dismissed on withdrawal with liberty.
My lord, obliged. My lord.
Please, Your Lordship. My lord, the judgment and order dated 9/8/2024 passed in WPC number 233/2024, my lord, is not complied till date, my lord.
Heard counsel for parties issue notice. Returnable 4 weeks, steps on the respondents by registered post 80 as well as usual post within 1 week. Okay.
Highly obliged, Your Lordship.
I think
Yes.
My lord, and speaking order is under challenge, my lord, by the LIC, my lord, notice is got to go, my lord. My lord may be pleased to find,
Why was it placed before division bench?
my lord, wrongly went, my lord. Then, my lord, we prayed, but after a long time, it has been again listed, my lord. Speaking order, my lord.
Council group parties issue notice. Returnable for files. On respondents by registered post ID as well as usual posts within 1 week from today.
My lord.
That will be listed after returning out.
Obliged, my lord.
In this case, to place instruction on the respondent lordship.
Who is the respondent, Mr. Dr.
Dr. Lordship.
What is your prayer?
Well, regarding release of some bill lordship or amount regarding LTC bill lordship.
As we call up after some time.
Lordship.
EP doctor. APS.
Last occasion, my lord, your lordship, by order dated 37/2025. I'm that day, I'm Lexin court number 1, my lord. Your lordship is said that regarding whether any appeal that may have been preferred by the petitioner in terms of the order dated whereby disciplinary authority had imposed. My lord, appeal was filed, my lord. The appeal is annexed, my lord.
No.
Annexer
Appeal
17
pending or disposed of?
Lordship,
pending, my lord.
no, Lordship, a speaking order has been passed on as per 20th of August, Lordship.
No. In the appeal.
Yes, Lordship, the appeal has been was
Rejected.
preferred.
Appeal has been filed 28th of August.
Huh? No, Lordship, I have a speaking order. We have passed the speaking order. Lordship allows, I can bring it on record. Also, we have received a comment.
I filed an appeal case, my lord, 76 on 20th August 2024. Page
24.
76, my lord. My lord, if this order is passed, kept in file without communicating to
Lordship,
me,
that-
that is non-its law.
On that part, Lordship, I have, if the petitioner was informed or not, Lordship,
On the same day you file?
Yes,
You passed an order.
20th of, Lordship, the 20th of August 25. The-
25.
Yes, Lordship.
Okay, I don't know what I have.
That I have this copy of the speaking order with me, Lordship.
So, it
Lordship,
is
I can provide a copy.
So what has happened? Appeal rejected.
No, yes, Lordship, he was penalized, Lordship.
Was there any change in the order passed by the disciplinary authority?
Where's the Lordship here?
Where is the disciplinary authority order? Page 72.
Disciplinary.
Page, my lord, 72, my lord. My lord,
Deduction of 20%.
yes, my 3 charges was framed, and out of 3 charges, my lord, 2 charges was exonerated. Only charge number 2, I am given, my lord, your lordship, page 73, my lord. While he was married, my lord, page 70, while he was performing his duties as Treasury officer, Musalpur Treasury, he had even made a payment to the wife of a deceased subscriber, Srimati Kanchan Boru, wife of so and so,
all
without
right.
any.
We are only asking you if there is any change in the appellate order.
Lordship,
Has the appellate order altered the punishment imposed?
no, Lordship, here, where is some? Lordship, 20% pension, Lordship.
20%.
Yes,
So
Lordship, upon the delivery, as per Rule 21A of the Assam Service Pension.
you
Rule.
serve a copy to him.
Yes, Lordship,
You want, you will bring it on record.
yes.
My lord, during the
Mr.
pendency of the petition, they passed this order, my lord.
Huh.
Because of that,
Mr. N.
we
Boran,
have filed.
learned counsel for the petitioner. And Mr. H. Oliha appearing for
The Finance Department, Lordship.
Finance Department.
Respondent number 1, 2, 3,
All the respondents.
all the respondents.
The petitioner is agreed by the order, impugned order dated 12/8/2024 passed by the disciplinary authority, whereby the authority accepted the findings of the inquiry officer and imposed a penalty of within quotes deduction of 20% of pension for a period of 1 year upon the delinquent officer Sri Toroni Polita AFS retired. The period of suspension undergone by the petitioner was directed to be treated as on duty for the purposes of pension. However, he was not entitled for salary under the said for the said period of suspension, except for subsistence allowance as sanctioned. So, being agreed, the petitioner preferred an appeal before the appellate authority by appeal dated 20th August 2024. Stop. The petitioner has assailed the impugned order dated so and so, imposing a punishment of 20% of deduction of pension, deduction of 20% of pension. Stop.
For a period of 1 year, Lordship.
For a period of 1 year. Correct. During the pendency of the writ petition, it is informed by the Standing Counsel findings that the appeal preferred by the petitioner also stood disposed of on 20th August.
Yes, Lordship, 25.
2025, whereby the appeal preferred was rejected. Stop. Counsel for the respondent will serve him a copy.
Yes, Lordship.
Will serve a copy on the counsel for the petitioner. Petitioner, if so advised, may bring it on record by filing in additional affidavits. Stop. Considering the issues raised, this court is of the view that the matter will require hearing, will require examination, issue notice, returnable 4 weeks, steps. Since the respondents are represented by Mr. Cholia, notices are waived, extra copies be furnished within a period of 1 week from today. Extra copies be furnished on the Standing Counsel.
I pay people wrote my 20% may not be deducted, my lord, because of that. If that portion may be stayed because of that due to pendency of this petition, my lord. If we are rejected my petition, then I will pay, my lord.
Till the next date fixed, the imposition of punishment by the impugned order dated so and so shall not be given effect to.
Much
List again on 24th
March
of September.
Lordship. March, please.
Item 5.
Matter relates to professional development, Lordship. The respondent number 5 is supposed to obtain the instruction.
Lordship, I have received instruction, Lordship. As per my instruction, Lordship, the case of the petitioner was placed before the DLC, Lordship, and DLC approved it on 30th of August 2026, Your Lordship.
You bring it on record.
2016, Your
You
Lordship.
bring it on record. I will
Now-
give an affidavit.
Yes, Your Lordship.
Bring it on record. Heard. Mr. M.K. Bora, counsel for the petitioner, and Mr.
Notice is not issued, Your Lordship.
R. Deka, appearing for Dima Hasao,
Yes, Your Lordship.
and Mr. Dhor for Handloom and Textile.
My lord, I am for 2 and 3, my lord.
Huh?
Respondent number 2 and 3.
2 and 3. Who is for 1?
One.
It was S. Borua for respondent 1, Mr. R. Dhor for 2 and 3. S. Borua for 1, 6 and 7, Mr. Dhor for 2 and 3, MSR Deca for 4 and 5.
Yes, your lordship.
Since the council represents the respondents, notices are waived, extra copies we furnished within a period of 1 week from not to be listed after returnable date.
Obliged.
Extra copies we furnish.
On the last occasion, my lord, I directed for some instructions. Order dated 4/8/2025.
Health Department.
Health Department.
Health Department. Yes, Mr. Bora, you here?
Yes, my lord, I have this.
Appeal disposed of? Not.
Not because of, my lord, it is under consideration, my lord.
Oh. So when is it likely to be final stages? So we'll defer it for 2 weeks. Will you place the status?
Yes, my lord, because it said that the matter is presently in the final stages of disposal.
Therefore, 2 weeks. How much time will you require? 3 weeks.
2 or 3 weeks, my lord.
All right.
3 weeks, my lord.
In deference to the order dated 4/8/2025, Mr. D. Bora, Standing Counsel, T.P. Bora, Standing Counsel, Health Department, has on instructions submits before this court that the appeal preferred by the petitioner is under consideration and is presently in the final stages of disposal. So, considering these instructions placed before the court, this court is of the opinion that the matter will be deferred for 3 weeks. The Standing Counsel will apprise the court about the status of the appeal on the next date fixed. List again after 3 weeks on 15 October.
Obliged.
Obliged, my lord.
May please, Lordship. I pray for about 10 days time, Lordship. I have not received any instruction, Lordship.
10
regarding
days.
The status of appeal, Lordship.
10 days.
10 days.
On the request made by Mr. H. Chakraborty, learned government advocate, praying for further 10 days time, matter stands deferred to be listed again after 10 days. List again on 5th.
Obliged, Lordship.
Mr. Chetri. Chetri, please for the petition.
Please, the Lordship. My lord, petitioner before your lordship was appointed as a compassionate appointment, my lord. On 1/25/1/21, she was working regularly, my lord. Thereafter, my lord, some approval was not given. We filed a writ petition.
She was not
And-
allowed to work.
And from 24th July, my lord, she has been prevented. For the want of approval, my lord, we have already filed a writ petition. That case is pending, my lord.
Approval for what?
Approval for seeking, my lord, a compassionate appointment, seeking approval for clear of all financial benefits.
State level committee has not approved the appointment of the
And
petitioner, my
district
lord.
council area, my lord.
Petitioner challenge it, my lord, by way of writ petition that is pending. And as the appointment of the petitioner has not yet been approved by the, my lord, SLC, my lord. So, my lord, his appointment was kept in abeyance and appointment was irregular, my lord.
My lord, no, my lord, I was working, my lord, all alone, my
My
lord.
No, you
How
are-
SLC
All
without
alone, my
approval
lord,
of
and
SLC,
they
my lord.
themselves said, my lord, that, my lord, they don't need any approval because this is a sixth schedule area.
My lord, it is not
For
correct, my lord.
appointment of
It is
grade
not correct.
3 is
Approval
correct,
of the
my lord.
SLC is required in respect of the
No, my lord,
appointment
they
in
have
state
written
sector. In the state sector, in the council sector, my lord, approval of SLC is not required. And it is the petitioner appointment in cooperation department. It is the, my lord, state sector. State sector SLC approval is required, my
Lord,
lord.
kindly have a look, my lord.
As per the notification of 2015.
That will not be
What is
applicable.
the status of the other writ petition where you are challenging?
That is, my lord, pending, my lord. Which is fixed on, my lord, 9th or 8th, my lord, I cannot recall exactly. They themselves said, my lord, approved by the district level committee, compassionate appointment, the chairmanship of the principal secretary Karbi Anglong. Since the autonomous council is sixth schedule, it is empowered to appoint grade 3, grade 4, not referred to the state level committee for concerning person. It is their stand.
But these are official communications.
My lord.
You show it to Mr. Sutia.
Yes, yes, I'll give it to him.
So what will you do with this copy?
My lord, there,
Doesn't give you a right.
my lord, rise in that, my lord, they themselves said, my lord, it is not
Show it to
required.
them, you confront to the
It is not
respondents and tell
required, my
them.
lord. So I may be permitted to work, my lord, subject to the outcome of the writ petition.
No, but
He is a widow
tomorrow,
lady.
tomorrow, if there is if we find that the decision of requiring an approval from SLC is required or is correct or is necessary,
That has been,
then
my
your
lord, 3 years that, my lord, it is no more there, my lord. 3 years, it is already satisfied by the single judge.
so that we'll have to first ascertain. You are already challenging it by way of a writ petition.
My lord, that is, my lord, for not giving the approval.
Exactly.
That
On one hand, you are
and
challenging
that, my lord, I have been stopped all along, my lord. I was working, my lord.
Mr. Bormian. You see, you are challenging, you are filing a writ petition before the court,
Yes, my lord.
seeking a direction that the SLC approval should be given.
My
That
lord,
writ petition is pending.
my lord.
Here you are filing another writ petition saying SLC approval not required.
My lord, I am not saying on, my lord, I have been prevented, my lord, since they have said, my
No,
lord.
but you are relying on this document to say
My
SLC
lord,
not
they
required.
said, my lord, approval. Approval is no way connected in the instant case.
Then why are you filing that other writ petition?
Other
Taking
writ
direction?
petition, my lord, they have already, my lord, they said that my case was kept in abeyance, my lord. That we put.
We let both these matters be listed together. When is the
Yes,
other matter
yes.
fixed?
On 8th, 9th, my lord.
Right.
The list that I have annexed, my lord, at page 45, my lord.
8. 8-4.
5534. WPC of 23. Page 45.
Page 40. 45.
My lord.
They submitted that a writ petitioner has filed another writ petition in relation to his appointment in compassionate ground, where he is assailed. Where the petitioner has assailed the SLC minutes, wherein the consideration of the case of the petitioner was deferred on the ground that the mother-in-law of the petitioner did not have a balance of 3 years service at the time when she died. And the petitioner therefore could not have been given compassionate appointment in terms of clause I.
I have already appointed, my lord.
This is what we are reading from the order
My lord.
dated 1/6/2015. Stop this. But Mr. Sutia, in this matter, there is already a direction that she would have to be paid her salary.
My lord, that is for that reason, my lord, the SIU approval has not been given, my lord. Salary could not be paid. But as there is a direction from this honorable court, so we have to pay before from the date of appointment till the rejection by the SLC, my lord. That period, my lord, we have compelled to pay the from the council sector. State government has not paid the salary, my lord, due to non-approval of the, my lord, by the SLC.
This
my lord.
matter is pending and it is submitted by the council for the petitioner. It is
fixed.
due to be listed in the month of September.
Date to side yet.
In that view of the matter, the court is of the view that this
Yeah.
writ petition should also
Not to call you.
be listed along with WPC
8-9.
5534 of 2023.
It is fixed on 8-9.
It's fixed, earlier writ petition is fixed on 8/9. Accordingly, both these writ petitions we listed on 8/9.
Notice has not been issued. Let me.
Let it be listed, we'll
Yes,
put on
yes,
that day.
I have already served them extra copy.
In the other writ petition, notice issued.
Notice
Yes,
issued,
yes.
madam.
So there you answer, we cover the same issues.
Item 9.
My lord, item number 9 and 12 both relates to appointment of Kabura. My lord, this is the second round of litigation. We have exhausted the statutory appeal under section 162 of the Assam Land and Revenue Regulation Executive Instruction. Now,
We'll issue notice today.
Lord, kindly see the order that order not to have.
Notice to issue code.
Lordship annexer 13. Page 72.
72. Yes,
Order.
That order has not been silenced.
not challenged.
No. Lordship, may kindly go to the pair also. Nothing has been, they are only seeking, my lord, the exercise the appointment of the respondent number 5. And even then the director of land records is also not a bad made party.
Oh,
Better to find, my lord.
you have to put this to challenge.
Lord, we'll just amend it, amend the prayer, madam. The Lord, we'll keep it next week, madam, we'll amend it.
Heard Mr. B.D. Kaur. You can say Mr. B.D. Kaur, Senior Counsel, assisted by MS Swenson, submits that the prayer in the writ petition requires amendment. He seeks liberty to file appropriate amendments as sought for. Mr. J.K. Goswami for the state and Mr. J. Handig appeals for the Revenue Department. List next week.
Yes, sir.
12
also same.
12.
Inadvertently, it went, you will correct it.
12. All right. 9 and 12 next week.
Item 10.
May I please, Your Lordship? Sir, I am a Lat Mondal, Your Lordship. My 2 increments of my salary was deducted, Your Lordship, on the basis of departmental inquiry, Your Lordship. Impin order is page number 25, Your Lordship, Annexure G, Your Lordship. Annexure G, page number 25, Your Lordship. Impin order.
Appeal file. Is there any appeal file?
No, not file.
Go and file an appeal. Departmental appeals are there.
Yes, Lord.
So there is an FIR, Your Lordship, lost, and that FIR was submit final report, Your Lordship. I have
Whatever it
annexed
may be, go and file an appeal. Urge all this before the appellate authority. Appeal is there, review is there.
Right.
Why writ? Heard counsel for parties, petitioner is agreed by which order?
Order
You're challenging
dated
which order?
11/06/2021.
Page number
page number 25.
25.
Yes.
25 to 80.
Is challenging the order dated
11
11 June
Salary increment
2021
to
passed by the Deputy Commissioner at Hemaji Division, whereby pursuant to an inquiry instituted against the writ petitioner and on the basis of the recommendation of the inquiry officer,
25.
punishment of deduction of 2 increments
Of the present petitioner.
of the present petitioner was imposed under Rule 7 of the Assam Discipline Services Discipline and Appeal Rules 1964. Being agreed, the present writ petition has been filed. Para. Counsel appearing for the respondent submit that in respect of orders passed by the Deputy Commissioner, there are statutory remedies available of filing an appeal and thereafter a review. Appeal and a review.
It may be.
Is it appeal?
Appeal may be filed against the. Deputy Commissioner.
162.
No,
No.
not the mother
This-
that Gangura, Lordship.
it
It
is-
is a appointment of the
Oh.
Disciplinary, it is under disciplinary and appeal rule, Lordship.
LRA, Lordship.
Oh, this
Land
is
record
lot
assistant.
Mondal, sorry.
Yes, lot model. The departmental proceeding was done, Lordship, and thereafter, Lordship, or this deduction of 2 increments order was passed by the Deputy
That's an
Commissioner.
appellate. remedy of filing a departmental appeal has not been exhausted by the respondent. Stop. Why are you, is it your case that the inquiry officer, disciplinary authority are not authorized under the rules to pass the orders?
Yes.
What is the ground for challenge of this order?
Lordship, actually, there is an FIR, Your Lordship, in connection with same offense, Your Lordship, and that FIR finally, final report was submitted in the page number 28, Your Lordship. I have annexed, Your Lordship.
After participating in the.
When was it submitted?
Final report submitted, Your Lordship. By the
When?
concerned police.
Which date?
Final report did not mention, but order is the 1st November of 2023, Your Lordship, page number 28.
Was it brought before the authorities?
Not, Your Lordship.
This is 23. The order is passed in 21.
24, Lordship.
Yes, yes.
Subsequently, Your Lordship.
Huh? Submitted that departmental remedies are available. Stop accordingly. Since the present writ petition has been filed putting in, assailing the impugned order dated so and so is not on the ground of lack of competence by the disciplinary authority and of rigor in violation of natural justice or end of rigor in violation of any of the provisions of the Discipline and Appeal Rules 1964. The petitioner should be relegated to filing a departmental appeal against the impugned order. Accordingly, the writ petition stands closed without expressing any opinion on the merits of the case. The petitioner will approach the departmental authority prescribed under the so-and-so rules and file necessary appeal if so advised. Needless to say, the petitioner is still aggrieved by such orders as will be passed by the appellate authority. Remedy of approaching this court will always be open. Yeah.
May
Yes.
please your lordship. My lord, the petitioner before your lordship is presently serving as Assistant Executive Engineer Civil under Public Works Roads Department, my lord. On 6/3/2025, my lord, the selection board was held for promotion to the next higher post, that is Executive Engineer Civil PWD.
Seal cover.
The petitioner case was considered and placed on the seal cover for the reason that there is a FIR pending against him. As your lordship knows, the law laid down by the Honorable Supreme Court in KV Janakiraman versus Union of India reported in 1991 for STC 109 that unless and until a search memo in a departmental proceeding or a search sheet in a criminal proceeding is filed, it cannot be said that there is a pendency of any case. So, my lord,
Will issue notice here.
your lordship will kindly issue notice and the promotions may be made subject to outcome of the writ.
Yes, Mr. Dhor.
Yeah.
Counsel for the petitioner. Issue notice as per number 4 weeks, Mr. R. Dhor. Standing counsel PWD represents all the respondents. Therefore, notices are waived. However, extra copies be furnished within 1 week from today. You are challenging whose promotion?
No, I'm not saying, my name is already there, my lord. I have not been superseded. Only my case has been put on the seal cover on a wrong.
But you said promotion will be subject to.
However, my lord, on the recommendation of the selection board, promotion has been effected wherein my name finds place, but it's withheld. So they have to.
You have been recommended.
I don't know. I have.
It is in seal cover.
It's in seal cover, but in the list of the gradation list, it is mentioned as withheld.
No, you submitted that promotion subject to outcome. What is that promotion? Your promotion.
No, the other promotions.
Then you'll have to specifically assail it. You are agreed by only one post.
Yes, I'm on.
So whose promotion are you agreeing?
Technically, I am not being superseded, my lord. The seal cover has to be open.
Otherwise, even my lord, if writ petition is allowed, he will get his promotion.
He'll get provided there are vacancies.
There are vacancies. And if he doesn't assail, my lord, Somebody has to come down.
No, that is why I have an exact list where my position is intact and it is shown as withheld. So you will kindly come to that,
It's not recently allowed any problem.
Since it is submitted that the petitioner's case was also considered along with other candidates found within the zone of consideration, but his case was kept in seal covered in view of an FIR being filed.
FIR being pending, FIR
filed
Vigilance PS case number 01 of
in
2020.
in view of the investigations carried on in vigilance PS case number
01 of 2024.
01 of 2024.
There is no such
The
thing.
results in respect of the selection board / the committee vis-a-vis the writ petitioner has been withheld. It is the submission of the petitioner that he fulfills all the criteria and comes within the required zone of consideration, including his position in the seniority list. Therefore, had his case not been kept under seal cover, he would have been promoted. So it is his submission that on the date the selection committee proceeded to consider the case and put his case under seal cover, there is no charge sheet filed in the vigilance case against the petitioner. Therefore, it is submitted that the same is in conflict with the law laid down by the apex court in KV Janaki Raman, reported in so and so. Stop. He therefore submits that the department be directed to keep one post vacant in the cadre of
Executive Engineer Civil PWD roads.
Executive Engineer
Civil
Stop.
PWD roads.
PWD roads.
If
Correct.
already, my lord, if it's not filled up.
Having heard counsel for parties and upon perusal of the materials before this court, prima facie it is seen that on the submissions made before this court, it is seen that petitioner's case was kept under seal cover, and although no charges were framed in the vigilance case, and therefore, unless cognizance is taken by a competent court of criminal jurisdiction, cases are not required to be kept under seal cover in terms of the law laid down by KV Janaki Raman. Under such circumstances, in the interest of justice, the court directs one post in the cadre of executive engineer,
Civil
PWD roads shall be kept vacant or shall not be filled up till the next date of listing.
My lord, the DPC of 6/3/25. It's in between 5 months.
No, promotion order was issued on 24/6 last month.
You come and inform us if no posts are available. We'll notify it. If prior to today posts are all filled up, you apprise the court, will modify the order.
My lord.
This matter on 15th. 15th
15, my lord.
September.
My lord will make only indicate that to be kept vacant if not already. My lord, if we have already, my lord.
You intimate the court that this order could not be implemented because posts were already filled up. Where is the difficulty?
There is no difficulty.
We are not staying it. We are only saying don't fill it up till the next day.
My lord.
Yes.
Deep level.
14.
Wait, please, your lordship. Lordship, I may be allowed to withdraw this petition, lordship. Some Order has to be challenged that.
On the instructions received, the counsel for the petitioner submits that the petitioner seeks to withdraw the writ petition with liberty, as certain corrections are required to be incorporated. Accordingly, writ petition stands dismissed on withdrawal. Mr. UK Goswami, learned CGC, appears for the response. Yes.
That's much.
Assam University has advertised some post of lecturer, reader, and professor. Advertisement dated 18/6/2023 to 2003, page 38. Lordship, thereafter petitioner has got the appointment in 2004. Page 38 is the advertisement dated 18/6/2003. Lordship. Lordship got it.
38.
18/6/2038.
Yes.
This is the advertisement for the post of professor, reader, and lecturer. After the petitioner was selected and petitioner were appointed, I've enclosed the appointment letters. These are
Which post? Which post?
some are lecturer, some are readers.
Okay.
Page 39 onwards,
All right.
18 April 2004, the offer of appointment. Report was Mondol. And thereafter they have submitted joining report, page 40. All the petitioner has accordingly joined, Lordship, in time. The Government of India has issued an office memorandum. Lordship will find page 79.
Yes.
Lordship got it. Page 79. Lordship, coverage of under central civil service pension rules in place of national pension system. Those central government employees who were recruited against the post and vacancy advertised and notified for recruitment on or before 22/12/2003. Lordship, got it. Lordship, as per this notification, the government, the petitioner have to file an application to convert their to national pension from the NPS to the regular pension. Lordship will find page 80. Page 80, Lordship, 4. The matter has been examined in consultation with the Department of Financial Service, Department, Personnel Training, Department, Expenditure Department, and Legal Affairs. In the light of the various representation, reference, and decision of the court in this regard, it is now been decided that all cases where central government civil employees has been appointed against vacant post which has advertised and notified for recruitment and appointment prior to the date of notification of National Pension System 22/12/2003 is covered under National Pension System, and joining of service on or before 1/1/2004 may be given one-time option to be covered under the CCS Pension Rule 1972. This option may be exercised by the concerned government servant latest by 31/8/2023. Lordship got it. Thereafter, Lordship, as per this notification, clause 7, those have given the option. The NPS account of such government servants shall consequently be closed with effect from 31st December 2023. Clause 7, Lordship, last portion.
Yes.
Thereafter, Lordship, Assam University has issued a circular, page 82. Lordship got it. In pursuance to Office Memorandum 33/2003, issued by Additional Secretary, even Government of India, a one-time option is granted to all employees appointed on or after 1/1/2004 against post of vacancy which were advertised, notified for recruitment appointment prior to the date of notification of National Pension System, and is covered by the under NPS on joining on or after 1/1/2004 for incorporation into CCS Pension Rule 1972. All concerned are requested to submit their option within 31/8/2023 for further consideration. Accordingly, all the petitioner has submitted, Lordship, page 83 onwards, is the option given by the petitioners. Thereafter, Lordship, second office memorandum is in issue. Lordship will find page 92. Page 96. Page 96 is circular. Same officer, page 96. In continuation of the circular, dated Iman, issued from this end, all concerned are requested to submit the requisite information in format. Now they have submitted directed to in sub format. Enclosed here within the schedule date of 31/8/2023. Format is enclosed at page 97.
Yes.
Accordingly, all the petitioner has submitted in the format page 99 onwards. Lordship got it? Page 99,
Yes.
100. These are the Lordship the submission by the petitioners. Lordship, till date, Assam University has not done the requirement because it has to be done within a specific date. Date has been mentioned in the circular. And it was stated, Lordship will find at page 92, again, office memorandum, which I want to show Lordship. Page 92. Clause 4, page 93.
93.
Lordship. Option may be exercised by the concerned government servant latest by 31/8/2023. All the petitioners have submitted the option within date. And thereafter, Lordship, clause next 8(1). The amount may be credited. Adjustment of the employee's contribution in the account may be credited. Individual GPF account and account may be recasted, permitting up-to-date interest authority money mark. Adjustment of government contribution NPS account to be accounted is head number iman, deducted recoveries, measured head number iman, pension and other equipment benefit. These are the circular. Now 9 Lordship, page 94. The cases those government servants who fulfill the condition mentioned in OM dated, who exercise option to switch over the pension scheme under CCS Pension Law 1972 may be settled by the Administrative Minister Department in accordance with these rules. Issue of consultation the Ministry of Expenditure Iman. But till date, they have not done this. So Lordship, similarly situated person from other universities has approached different high courts. I have enclosed the high court's order. Lordship will find page 122, so Jharkhand High Court's order. Jharkhand High Court has already allowed, and Allahabad High Court also allowed. Page Lordship will find page 128. That as per circular, they are entitled for CCS pension rules, but they have kept it pending. Until that NPS contribution is deducted.
There is some order of the Supreme Court also.
Supreme Court, we have approached the Supreme Court. Supreme Court has directed to approach the concerned liberty. Page 123.
You have approached.
Lordship, we have approached.
Against which order?
Against for getting the benefit. Directly we have approached and
under 32.
Under 32. We have approached all the petitioners. This Allahabad High Court also did.
That is dismissed.
No, that was liberty given to approach the, without giving petitioner shall be liberty to approach the other forum as may be permissible under the law. Page 121. And thereafter some approach the Allahabad High Court and some Lordship Jharkhand High Court. We have approached Guwahati High Court.
We'll issue rule here.
Lordship. Only thing is Lordship.
Issue rule, this will require some hearing. You file your
Lordship.
affidavit, reading, whatever. Heard counsel proper.
May I submit one thing, Lordship? Lordship, matter has been already settled. I think.
No, Lordship, there is some.
No, I'm not praying for disposal, Lordship. Lordship may dispose this matter at the admission stage. That will be better, Lordship.
Heard learned counsel for the petitioner, issue notice written about 4 weeks, Mr. SCKL.
For 6 and 7.
Represents respondents 6 and 7.
Lordship.
And Mr. Chamua for
5.
Respondent 5. Anyone for union? Mr. D. Pegu appears for respondent number 1, 2, and 3.
4 also.
4. Since the respondents are represented by counsel, notices are waived, extra copies be furnished within a period of 1 week from today.
Today itself, I'll submit.
Respondents may complete their instructions and file necessary affidavit with regard to the issues raised by the petitioner. List again after the returnable date.
Before that, Lordship, kindly say page 80 again.
Page?
Page 80.
80.
80. Of the office memorandum, page 79 is third. Clause 7 of it. NPS account of such government shall consequently be closed with effect from 31st December 2023. Till that NPS account is continuing.
But we'll examine it, let them have their instructions.
There is a instruction of the UGC all the university, because these are the autonomous council. So notification referred by Malandipet is not applicable to autonomous bodies.
Lordship will kindly see.
There is a
No,
notification.
let the
latest
we'll consider all this on the return.
Lord-
And Lordship may record then, the interim order will be considered on the returnable.
Notice also on the interim prayer, returnable on 24th. Interim prayer. Notice on returnable on 24th.
Obliged.
24th
Highly
of
obliged.
Milord?
24th of September.
September.
Highly obliged.
Then 16.
Very Lordship. My lord, the petitioner was appointed as GD head constable in the year 2008. After serving more than 10 years, my lord, he was appointed as junior engineer electrical by order dated 15/11/22, that is page 22. My lord, thereafter, petitioner was sent on deputation. And he applied. For that, he was sent for deputation, and he is on deputation on the verge of completion of the deputation period. Now, as per rules, if the person concerned is working more than 10 years, he is entitled to be appointed as junior engineer BSF setup. So we applied through departmental proceeding, that is through proper channel, that I should be absorbed in that post. That Lordship may kindly see page 25. That is my application, and it was forwarded by my officer, that is page 26.
We'll issue notice today, Mr. Mahmood.
My lord, that is them. We have some interim prayer.
What is that?
That Lordship may kindly see page 13. Because
You are now posted as what?
as
Signal. Sorry,
junior engineer electrical and in BSF setup on deputation.
on deputation.
On deputation. But thing is this, when we have completed more than 10 years, we are entitled for absorption permanently. So if they send back us to our original post, then my lord, we will suffer heavily. So that's why.
Why heavily? That is your.
Heavily means, my lord, now we have gathered past experience in electrical matters, and regarding combatant duty, we have almost.
What is your parent posting?
Parent posting is GD constable. My lord, the other day.
GD constable or sub inspector constable?
No.
GD.
No, original post was GD head constable. Thereafter.
In your prayer, you are writing it as sub inspector GD.
Prayer, my lord, there is a little mistake. I will make submission. But this is the earlier order, my lord. In similar case, your lordship has passed order, and I may kindly be allowed to correct a little order, that is GNation. In everywhere it is correct, but in the prayer it is written. That may kindly be allowed to.
Wrong prayer.
It is computer.
So we have issued notice only.
Also on interim prayer.
Also on interim prayer.
Yes.
Had done counsel for parties issue notice. Returnable after 2 weeks. Mr. G. Pegu, learned CGP appears and accepts notice on behalf of all
respondents.
all respondents. Notice also on the interim prayer, returnable on 17/9. So it is submitted by the counsel to the petitioner that a similar writ petition being WPC 4619 or 2025 is listed on 17/9. Accordingly, both these writ petitions will be listed on 17/9. Respondents may complete their instructions and file necessary affidavit. If so advised. Yes.
I'm correcting a little portion.
You will correct it in the order. You don't have to do that. On the next day.
And then my learned friend's copy will say otherwise. So.
No, you correct it in your learned friend's copy, in your copy. In the court copy, we'll correct it by way of an order.
Okay.
Otherwise, you'll have to file amended course title.
May I please your lordship? Lordship, in this case, lordship, the petitioner is a government, retired government employee who joined in service on 8 October 1979 and retired from service on 31/12/2018. After the retirement, lordship, his entire accept the GIS contribution amount of rupees 70,000. All other benefits that has been released, and the amount your lordship will find at page number 17, lordship. Then GIS amount has also been sanctioned by the authority, Chief Conservator of Forest, lordship, that your lordship will find at page number 19, lordship. But though the amount has been sanctioned, but till that same has not been released to the petitioner.
Get your instructions.
Well, sir.
Heard Mr. D. Sharma. Waiting for the petitioner. Petitioner is agreed that the GIS contribution, the writ petitioner, has not been released by the authorities. Stop. Mr. R. Gugul, counsel representing the Forest Department, will obtain the required instructions in the matter. In order to enable him to complete instructions, extra copies be furnished within 2 working days. Let the matter be listed again on 8th of September.
Yes, sir. Highly obliged.
All right.
18.
May I please move? My lord, can the matter be passed over for time being?
Time being.
Yes.
Let it come on next Wednesday.
My lord, my senior is on legs, my lord, just for after some time.
At best, notice will be issued. He's challenging that his case has not been considered for promotion because there is a charge sheet and a criminal proceeding pending.
I have an interim prayer also, my lord, to keep one post vacant for group.
But this is a time-bound promotion. There is no vacancy as such or cadre strength. It's a time-bound. If it meets the qualifying service in the lower grade, it is automatically promoted.
It aside for the time being, let him come.
Obliged.
19.
May I please your lordship? The issue involved in this case is settled by your lordship as well as the division bench judgment, Syed Mohammad Fazle Rafi. The petitioner has been paid lawyer pension by deducting the length.
Is it covered?
Notice may be issued at this stage.
Why notice? You examine and come back. Where is that order?
My lord, page 59 is my lord, the details, my lord, subject detail. The name of the petitioner has been
Mr. Islam for the petitioner, Mr. Ghosh appearing for the PNRD. Anyone else?
I am for respondent 2 and 5.
Mr. T.C. Sutia appears for respondent 2 and 5. Mr. Choliha for
Finance Department.
respondent 3.
3 lodge.
The counsel for the PNRD, the counsel for the petitioner submits that similar issues have been closed by this court by passing appropriate orders. The respondents will examine the matter and apprise the court on the next date fixed.
And para 5, 6 and 7.
Can you do it after a while? Have a look and see.
I have seen the order, my lord. So far, idea, my lord, after a week, my lord, I will do it.
After 1 week. We thought we can do it. You can do it today if you can go through. No.
Wednesday?
Matter will be listed after 1 week. 29th. 29th?
Yes,
let the respondents examine the copy of the order furnished before the court by the counsel to the petitioner and apprise the court whether the issues stand covered by this order. Similar order.
Highly obliged, your lordship.
I think 20.
Ma'am, please allow.
Yes.
My lord, petitioner before your lordship is a was a science teacher in Oil India Limited, my lord. In pursuance to the departmental proceeding, he was dismissed from service. Thereafter, my lord, we preferred institute appeal under the rule, my lord. That was also confirmed the impugn dismissal order. So I am before your lordship, my lord. So my prayer at this stage, my lord, let the notice be issued, my lord. All the records has to come because, my lord, I was being prevented from the opportunity of
Will
hearing.
issue rule then?
Yes, my lord, a date may be
But
fixed,
counsel-
a record may be called.
Petitioner is agreed by the order passed by the disciplinary authority impugned in the present proceedings, as well as by the orders passed by the
Appellate authority.
appellate authority, which upheld the order of dismissal
Dismissal.
by
My lord,
the disciplinary authority. Accordingly, issue rule, call for records. The respondents are represented by Mr. A. Sharma. Let the records be called for, matter be listed up. On 28th of October.
Obliged, Lord, sir.
Lordship, I apologize. Actually, here, Lordship, our name, our standing council name has not been shown. That's why we missed this item today. Anyway, Lordship, yesterday we received some instruction, Lordship, that the matter will come up any other day, we'll place.
This is what matter?
Lordship, here the one employee of family court under the Guwahati High Court establishment.
Oh, I think it has to be before.
Yes, before the Debasis Burwa, Lordship.
In
This is
view
the
of the notification dated 8th of January 2025, matter be listed by the registry before the appropriate authority.
That's it. The name of the standing council Guwahati High Court may be shown. Lordship.
The registry will list the name, will show the names of all councils, including the standing council Guwahati High Court and Accountant General.
Obliged.
Well, not on Tuesday, Lordship.
We are not saying Tuesday, we are saying it will be
Lordship.
listed on a fixed date
Fixed.
by the respondent.
Obliged, Lordship.
Lordship, earlier also I have taken time, Lordship, but instruction not received, Lordship.
How much time?
Lordship, last chance may be given for 2 weeks, Lordship.
Mr. Chetri appears for the petitioner, Mr. S.S. Roy appears for the respondents. Learned CGC who submits that instructions are still awaited. He prays for 2 weeks' time. Prayer made is not objected to, list after 2 weeks.
Item 24.
Have you received it?
Yes.
Pursuant to the earlier order dated 5/8/2025, whereby Justice so-and-so was appointed as a prospective arbitrator and was permitted to submit the written declaration, the written declaration by the learned prospective arbitrator, Justice so-and-so retired, Guwahati High Court has been submitted.
This retired district judge.
Oh, sorry, district judge, not very side over. Who was appointed?
Mrinmay Kumar Bhattacharya.
Sri M.K. Bhattacharya, former district and session judge, Assam, huh? Not High Court. What is this?
This is an intimation given to me.
This is something different you've given. This is about Arunachal.
Oh, I'm sorry, I'm sorry, and there was some. I'm sorry. Let me see documents.
The learned arbitrator. And again, is Sri M.K. Bhattacharya, retired district and session judge, has submitted a written declaration disclosing that he has no conveying his consent and he has no difficulty in undertaking the arbitrations. Undertaking the arbitration if his appointment is confirmed. So, considering the written declaration received, the direction contained in the order dated so and so, 5/8/2025, hereby stands confirmed. Sri Mrinmoy Bhattacharya, former district and session judge, is appointed as the arbitrator aside the disputes and differences arising by and between the parties in terms of the agreement dated, in terms of the arbitration agreement executed. Petition accordingly disposed of.
Obliged.
Timing item 18.
It will according to order arbitration, it will try with the 61 disposal. If I wait. Yes, notice at this stage.
Notice will do, Lordship, but the thing is that some interim player is there. It can be taken into consideration, Lordship, because in the last location also what has happened, this in 2024, prior to that writ petition, another writ petition was filed, but that was disposed of pursuant to this review. But my case was not being considered. Only thing is that the pendency of a criminal case, because the charge sheet was filed 2021, now it is 2025. Even at the stage of PW is this still going on. So there is no certainty of how much time it will take to complete the entire process. So
But
this is
then
the
how
this is the only anxiety on the part of the petitioner.
no, but how can it be overlooked by the authorities?
Lordship. No, I am saying that there is in the review, this order which has been put to challenge, it is at page number 61. The only thing is that the criminal matter, the pendency of the criminal matter. But the fact is that if the petitioner is convicted otherwise, the ad hoc promotion can be taken into consideration for the case of the petitioner. Because the pendency of the criminal case and how much time.
What does the rule say?
Lordship, they have, in the review, they have mentioned, I'm just referring to the review. This page number 61. Page number 62. In spite of 6 months monthly review of cases, Lordship got it? In spite of the 6 monthly review of the case under seal cover as preferred at paragraph 3(1) above, if the disciplinary authority or the disciplinary or criminal case against the executive is not concluded, even after the expiry of 2 years from the date of effective of the seal cover, the competent authority may review the case provided due executive concerned is not under suspension, to consider the suitability for granting one ad hoc promotion to the executive. So the provision is there, Lordship.
Yes.
So may I submit? So this is the second round of litigation. In the earlier case that was filed, we had filed an affidavit. In that affidavit, we had annexed two things. One was that review, and the other was the policy based on which Oil India Limited has adopted the stand in the review. That policy also forms a part of the affidavit filed in the earlier writ petition. The ground taken in this writ petition is that in the earlier litigation, when in the affidavit was filed, this review order was there. So that was not under challenge. Therefore, they had withdrawn that case, and this new case has been filed encompassing this review order. But the actual fact of the matter was, when this policy was placed by way of the affidavit along with the review, and we stated that this policy is not under challenge, that was the ground for which they said we will take necessary actions based on this, and therefore they withdraw the case to file this new case. But in this new case, this policy is still not under challenge. Now we have a policy, a seal cover policy, which says that if a person, this is a time-bound promotion. This is not that there is a cadre and he has to fill up some post. Time-bound. If he has the qualifying service from grade B to grade C, he will automatically get it. Now, when his time comes, his prayer in this petition is that to consider his case in the upcoming DPC. It's not that today he is in the zone of consideration. There will be an upcoming DPC. He has asked to consider his case. If he has the qualifying service, his case will be considered. But because of the criminal prosecution or the case going on involving moral turpitude, therefore it will be kept under seal cover as per our policy. If I may just place this policy for consideration, which is the part of our affidavit itself, filed in the earlier litigation. Lordship will see at the top itself, at the time of consideration of the case of promotion, the details of the executives in the consideration zone for promotion falling under the following category would specifically be brought to the notice of the Departmental Promotional Committee for placing their case in seal cover. Number 3, executives in respect of whom prosecution of criminal charges on serious allegations of corruption, bribery, or similar grave misconduct, including moral turpitude, fraud, dishonesty, etc. is pending. Now, the case that is pending, which charge has also been framed, is on section 354, Lordship. There was an issue of sexual harassment within the office itself, and the lady who is also an Oil India's employee has filed this case where charges have been framed and the case is going on. We never say that promotion will not be given to him. We are just following our policy. Yes, Lord. The interim will not be considered. There is nothing to be considered in the interim aspect.
When a counsel for parties issue notice return for which petitioner is agreed that notwithstanding the provisions of the rules that the petitioner may be considered for grant of temporary promotion or ad hoc promotion to the next higher post. His case has not been considered on the ground that a criminal case has been filed and is presently pending. Stop. Whereas, par contra, Mr. A. Sharma strongly disputes the submissions. He submits that as per the rules governing the services of the Oil India in cases of criminal matters pending,
involving
the guidelines, a seal cover procedure is required to be followed. Stop. The promotion which the petitioner is seeking claim to is a time-bound promotion, and if he satisfies all the eligibility criteria,
yes,
he will automatically be considered for promotion. Therefore, keeping his case in the seal cover will not jeopardize his chances of being promoted, subject, of course, to the orders that may be passed by a criminal court.
Yes, in the pending criminal case.
Having heard the counsel for parties, this court is of the view that the respondents can complete their pleadings in the matter and file necessary affidavit. Since the counsel for petitioner has raised has submitted before this court for interim directions, let notice on the interim prayer will also be issued, returnable on
the 4 weeks class when it did. I'll file my affidavit in the meantime.
19th or 22nd?
22nd.
22nd of September.
Yes, Your Lordship. Obliged, Your Lordship.
Placed accordingly.
So extra copies, Lordship.
Yes, I'll serve it.
Pendency of the writ petition shall not be a bar to consider the case of the petitioner if otherwise.
In accordance with law or if permitted by
In
law.
accordance with law.
Yes, Your Lordship.
Obliged.
Obliged.
Items 27 to 43. Your Lordship, we have filed affidavit in this matter, one matter that will cover the.
Yes, my lord, an affidavit has been filed. by
Item
the-
number 29, my lord, WPC 6243/2024. The transport has filed affidavit, but ASTC yet to file. But we have directed the ASTC to release the file. My lord, may kindly have a look my affidavit.
Yes.
Paragraph 4, my lord, and the annexure is started from page number
Let
54.
me submit my affidavit.
Yes.
Annexure 1 series, my lord, page 40 onwards. There are several writ petition and there are different persons. We have directed the MD ASTC to release the liabilities from. I have annexed the instruction that I have received in different matter.
And this letter is of 13th of January, my lord. And
Which letter?
the letter by which my lord direction is given for release of the fund, my lord, which is annexed in the affidavit filed by my lord, colleague, my lord. On page number 40, the letters are there, my lord.
Who is representing ASTC?
ASTC, the new counsel is Advocate A. Chamua, my lord. I have informed today morning. A. Chamua.
Why is he not here?
I'm
What
not-
is the status of the ASTC? Yes,
Lordship, am I seen the
call him, call him, call him. Please call him immediately.
In fact, lordship may dispose of the matter also if we agree.
How much amount is required to be granted?
I am representing from item number 28 to 43, my lord, 16 petitioner, my lord. And the amount is, my lord, all of them.
What about the fund position of ASTC?
Lordship, we have released some amount of 1,875 lakhs already. And we have asked them to release from that amount.
No, no, what is their claim?
Their claim is much less. Altogether, most of it, I have not served all the petitions by the petitioner, lordship.
I have solved all the petitions, my lord.
Count কৰি দেখাওকচোন কিমান আছে।
You do one thing.
Yes.
You work on the claims.
My lord.
We'll take it up in the second half,
Lordship.
2 p.m.
Lordship, may I get the second copy of the honor?
Yes, of course. You take all the copies of the
My
second
lord.
copies.
I will calculate, my lord.
You calculate and tell us which petitioner gets which amount
My lord.
and for what purpose.
Lordship.
Yes, Mr. Somua, why are you not releasing the funds?
We have received sanctions from the government my lord, in January, sorry, July. The only paper sanction has been received.
So
The fund is,
what you do is,
my lord,
I've asked the standing council transport also. Since all the councils are not available,
my lord,
they will also assist you. You just give which petitioner is entitled to what amount as per their claims in the writ petition.
my lord.
Just prepare a chart.
Chart, a composite
We'll
chart.
Dispose of the matter and at 2 p.m. today.
My lord, to get that, I mean.
No, you find it in the writ petition only. What is their claim in the petition? That's all.
Then you have to verify again that claims are correct or not.
Exactly, we'll give you that permission, but we need to know the amount.
My lord.
Petitioner
My lord.
is claiming what amount?
My lord, at 2, my lord.
Yes, at 2. Take it up at 2. At 2 p.m.
Problem.
টাইম ওর কত থাকবে এটা কোট যায় মানে যে বিস্তারিত গুলো
অসিন্দা 6 months টাইম লব লাগিব নহলে কিন্তু কন্টেক্ট হ'ব 6 months পইচাটো পাই যাব
6 months যদি নকওঁ
6 months বুলিয়ে ক'ব নহলে আকৌ কন্টেক্ট হ'লে আননেসেসাৰি 6 months কৰি দিব
তিনিজন মানুহ বিচনা
50 crores দিছে
আপৰে কি কৰিব এসিছে পইচা কি কৰিব ইমান পইচা এসিছে
নহয় দিয়া নাই কাগজতহে দিলে সেই মাত্ৰ দেখালো 50 crores দিছে
নহয় আমাৰ পৰা আপোনালোকে ৰিলিজ কৰি দিবলৈ যিটো এমাউণ্ট আগৰ আছিলে যে 18 এটো আমাৰ এফিডেভিট দিয়া আছে ডিপাৰ্টমেন্টৰ হেতু পৰা ৰিলিজ হৈ লওক আপুনি
আৰু জুলাই 20 জুলাই দিনাখন সিএমএ সেংচন কৰিছে
হেতু বেলেগ এমাউণ্ট আগতে কিছুমান পইচা এমাউণ্ট অলৰেডি সেংচন হৈ আছে তাৰ পৰা দিব Departmental ASTC direction দিছিলে 1000 এফালে আমি লিখো এটো Yes, affidavit given.
এগুলো পাব লগা পইচা কিয় নিদিব?
Yes, কেতিয়া দিছে মানে জানুৱাৰীতে এইবিলাক দিছে এইবিলাকৰ কিমান কিখিনি অলৰেডি মানে লাইবিলিটিজ খিনি এইটো এমাউন্টৰ পৰা ৰিলিজ কৰিবলৈ দিছে তেওঁলোকে নিদিয়ে এসিসি বহুত বদমাছ
18 crore ঠিক আছে?
জি লেটার কিয়া
লোকো কোটে কিমান কয় আৰু নাই কিমান চুব নিদিব gone through with both all of us lordship gone through the case record
এফাল ঠেলি দে এইবোৰ চকীখন
on the day of filing this writ petitions my lord
এফাল আগত ঠেলি দে yes
on the day of filing this writ petition according to the writ petitioners my lord the total due is 3.56 crore my lord. But the information that I have received from the managing director ASTC my lord, just few minutes ago, the total dues of the ASTC my lord is 179 crore as on date my lord.
179
179 crore as on date. And we have received a paper sanction on to
179 crore
as on date.
but
Total,
that must be inclusive of so many other
yes, of course.
persons.
Total liability pension, retirement liability. So out of this petitioners that before your lordships, that dues is 3.56 crore subject to further verification. Because
So
out of this,
what is the amount received?
50 crore sanction only, my lord, not the fund yet.
What is the sanctioned amount?
50 crores.
Okay.
Now, my lord, the proposal is, my lord, that will be because some of the petitioners are out of total liabilities, my lord. Some of the persons are before your lordship, my lord.
No, that's all right. We are only concerned with these petitioners.
My lord.
So out
No,
of
we are
this-
ready to pay the
out of
moment.
the sanctioned amount, out of the sanctioned amount which you will receive,
My lord.
you will release.
Proportionately will release.
Not proportionately. You verify their claims and release the amount.
No, my lord, there are some persons, my lord, who are senior before those persons, they retired prior to these persons. My lord, the propriety demands that, my lord, that we have to consider.
So what
their
is
case.
it? No, you are saying 179 crores for the employees. Only
Yes.
for employees.
Only for employees. No, who is already retired. These persons, this liability is the tip of the iceberg. They are a huge liabilities. That is why we have to disburse the liabilities in a phased manner. The moment we receive the fund, we are disbursing.
When are you likely to receive the funds?
The money has already been sanctioned.
No, the amount has been sanctioned. Fund has not been credited to our account.
It will be given by finance department, it will come, madam. Within 3-4 months, it will come.
If lordship passes an direction to the government that this matter will be taken care of within a particular period, then we can in a phase manner, my lord, after verification of the claim.
In fact, lordship, in our affidavit, my lord, the page 40 onwards, we have already directed the ASTC to release the amount of the petitioners from the already sanctioned amount of rupees 1,875 lakhs, lordship. This is our affidavit.
No amount has been released to you.
Some amount.
Actually, what happened, some portion of sanction amount has been given. And when we file this writ petitions, my lord, and this is the amount which we yet have to be.
Yet to be received.
My lord.
So your
And-
claim was more than this amount.
Yes. some
Part
were
of which
received.
have been received.
Part of which is received, but the thing is that, my lord, out of the 16 petitioners which I have represented before your lordship, His condition is very bad, my lord, and to have.
No,
the
that
daughter's
way,
marriage, my lord.
see, there has to be a method of releasing this amount.
Right.
The individual claims cannot be considered that someone is old, someone is sick, someone is like that. It can't be like that. There has to be some scheme worked out by the authorities. All right, you listen to the order, heard counsel for the parties, these writ petitions have been filed. But who represents the other counsels,
My lord.
Petitioner counsel.
the other petitioners in the other matters?
Presenting from item number 28 to 43, and in 27. 27.
Only one lawyer is.
Only one is
One lawyer.
heard counsel for the parties. These writ petitions have been filed by the petitioners who had served in various capacities in the Assam State Transport Corporation. Is it still there?
It's there.
Assam State Transport Corporation. Stop. They've all opted for voluntary retirement.
No.
No, there is superannuated.
Retired person.
After attending the age of superannuation, but they.
After attending the ages of superannuation. These persons
Superannuated.
upon
Only,
attaining their ages of superannuation, these persons, the petitioners went into retirement. So, however, the claims in respect of the retirement and other financial benefits remained outstanding to be paid by the ASTC, inasmuch as the ASTC had undergone severe financial distress. Stop. The ASTC, being a corporation, is required to generate its own funds and sustain itself, including payment of salaries and other dues to the employees of the petitioners, employees of the ASTC, like the writ petitioners. Stop. However, considering the plight of the employees, including those before the court, the proposals were moved before the appropriate department in the government for release of funds. Stop. Since proper steps were not taken by the respective department at the relevant point in time, these petitioners have approached this court by filing the writ petitions seeking a direction to the respondents, more particularly the ASTC, to release the outstanding arrear dues payable to the petitioner. Stop. The writ petitioners in different writ petitions have different sets of claims, in financial claims in respect of the dues which they claim are outstanding and payable to them by the ASTC. Stop. From the pleadings available before this court, the claims made in each of these writ petitions are extracted below, showing the names of each of the writ petitioners. Stop. Where the respondent Transport Department has filed an affidavit in item number
29, my lord.
6243.
Yes, lordship. And I have annexed all the instruction I have received regarding other matters also. I have annexed in the same.
Has filed an affidavit wherein there is an averment that the amount necessary for disbursal of the claims of the writ petitioners have already been sanctioned, and the ASTC is now required to release the payments in respect of each of these petitioners. Stop. Better. And I'll go para till over you. The learned counsel for the state has also placed before the court the sanction order dated 2007-2025, whereby an amount of 50 crores have been sanctioned by the government for meeting the past liabilities of the employees of ASTC for the financial year 25-26. Better. The counsel for the ASTC, Mr. Samoa, A. Samoa, on the other end submits that although the sanction has been granted, but the amount is yet to be received by the ASTC. Stop. He further submits that these claims raised by the petitioners are the balance amount required to be paid to the petitioners, as most of these petitioners have been have already received part of their dues earlier. Stop. He further submits that the total amount required for meeting up these dues of the writ petitioners is to the tune of rupees 179 crores.
Well,
out of which the government has only sanctioned 50 crores.
but one thing, Miller, the list that we have submitted, Miller, this is their claim. But might have that they have already got some amount out of this amount. This is not the net amount they are supposed to.
Listen to the order. So we were only putting the facts which were submitting before the court. 179 is the proposal.
Well, 179 is the total dues of the employees.
Have you raised the proposal to the government or not?
Yes. After raising this, my lord, we are getting part by part.
Right. Out of the total financial requirements and for which proposals have been raised, put up before the government to the tune of rupees 179 crores, government has sanctioned an amount of rupees 50 crores.
Yes, ma'am.
But the said amount is yet to be received by the ASTC. Stop. He submits that upon receipt of the said amount, the ASTC authorities will have to verify the claims made by each of these petitioners and thereupon release the amount which is found to be due in respect of these writ petitioners, together with the claims of other employees who are
not before,
who are or may not be before the court. Stop. Better. Having heard counsels for the party and upon careful perusal of the affidavit, the petition, as well as the affidavit filed before the department, and also upon perusal of the sanction order dated 2007-2025 issued by the communicated by the Transport Department. So it is seen that the government in the appropriate department has sanctioned an amount of rupees 50 crores for being released to the towards the claims, towards the proposal raised by the petition by the ASTC for release of the service dues to the employees of the ASTC, erstwhile employees of the ASTC. or former employees of the ASTC, including that of the writ petitioners. So. It is seen that the ASTC, neither the ASTC nor the Transport Department dispute that service benefits and retirement benefits of the petitioners are due, and that same has not been released in full or in part because of financial shortfall in the ASTC. Stop it. It is also submitted at the bar that the sanction order reflects that an amount of ₹50 crores have been sanctioned. Although Mr. Samoa submits that the total amount necessary to disburse and meet up all the claims, for dispersal for meeting up all the claims of these employees is to the tune of ₹179 crores. And it is perhaps in response to the proposal, a part of the amount has been sanctioned to the extent of ₹50 crores. Stop. Under such circumstances, this court is of the view that since the claims of the petitioners are not disputed by the respondents, and the only hurdle that had come in the way for release of these claims is the availability of necessary funds. So now, in view of the sanction order, in view of the sanction of 50 crores, as seen to be communicated by the Transport Department by communication dated 2007-2025, although the counsel for the ASTC submits as on date, the amount has not yet been received, the writ petitions can be disposed of with the following directions. Number one, the ASTC will examine the claims of these writ petitioners, and upon due verification as necessary, the amounts found to be due should be released to the petitioners after deducting the amounts which have already been released, if required. Stop. Since it is submitted at the bar that there are other employees whose dues are also required to be released and who may have retired at an earlier point in time than the present writ petitioners, and therefore their claims will have to be decided as per the seniority of claims, the ASTC may work out the method of disbursing the claims to the petitioners along with other similarly situated persons. Stop. However, preference may be considered by the ASTC for disbursal of funds in respect of persons who are undergoing severe medical treatment or undergoing treatment for severe medical diseases, or are confined to their homes or hospitals because of illness. So the ASTC authorities will pursue their proposal before the government for release of the balance amount, and the government in turn will expedite the sanctioning of the proposals raised by the ASTC if the same are found to be necessary for dispersal of financial benefits to the employees of ASTC, like that of the writ petitioners. With the above observation, writ petition stands closed and disposed. The entire exercise is directed to be completed within a period of 180 days from the date of receipt of a certified copy of this order.
Obliged, my lord.
Only one thing, my lord. In item number 40, She is the widow of the employee, my lord.
Preference may be for claims can be worked out in respect of persons suffering from ailment and in cases of claimants who are this will open up a Pandora's box.
No, my lord, regarding the item 40, that's why I'm clarifying that she is not the employee, she is the widow of an employee. That is
Item 40, she is the widow of the petition. I do belek poldi beleng. Petition disposed of in terms of the above.
Just one line, my lord, if lordship pleases, my lord. The entire disbursal, ultimately, we have to receive the fund, then only we can pay, because we are based, dependent on the government. Though
Therefore, we had
government,
given you 6
Yes.
months.
my lord,
If
if
you
lord,
don't receive, you are entitled to file applications for extension. 6 months is the time. By this time, you'll receive, you'll work
if
out.
lordship
the
add
scheme.
one sentence, my lord, saying that.
No, then there is no point giving time limit.
No,
Because,
time limit, let it be there, my lord.
but when are you going to receive the amount?
No certainty, my lord.
That's right. So if you
That is why, my lord, if lordship
if
adds
you-
one sentence,
if you don't receive it within, let us say, 2 months, 3 months,
my lord,
you are entitled to approach the court by filing an application that 6 months was granted, but we have not received the amount. If required, we will pass separate orders or we'll extend the further time.
if that can be observed, my lord, just an observation, my lord, because we are dependent on them. Had it been the case that we have to pay from our sources,
What observation you want?
my lord, if lordship says that the, meanwhile, my lord, the government department, that is the finance and the transport, shall make an endeavor to disburse the amount.
All right, the appropriate department in the government will endeavor to release the amount sanctioned within a period of 30 days
Well,
from the date of receipt of a certified copy of the result.
Lordship already observed the department and the authority.
No, this is for completion of the.
Final 179.
No, this is for disbursement of the amount by working out a scheme.
Schemes.
But they cannot do anything unless you release the amount.
Yes, that is why.
Kindly record finance department also, transparent finance.
Who is appearing for finance?
Finance not a made party
No,
here.
no, later on the finance was made a.
We said appropriate department in the government. That's all.
Mal-
That will take place.
Actually, I'm for
Finance also.
one minute.
Yes.
সেইটো আপোনালোকৰ ফালে proposal নপঠিয়াব মোক কেনেকে
আছে, proposal দিয়া আছে, সেইকাৰণে 179 ৰ পৰা 50 দিলে। এই যে 170